Supreme Court today ruled that President Donald J. Trump is entitled to some immunity in his election interference case. The court ruled 6-3, no surprise, determining that presidents are immune from criminal prosecution for official acts, but not quote unquote unofficial acts. The justices stopped short of saying whether Trump's conduct on January 6th is protected. They kicked that decision back to the lower court, which will determine if charges in the indictment fall under the determination of official or unofficial. The question is, what does that mean for Donald Trump? The ruling pretty much all but guarantees that the former president will not face trial in the January 6th case before the November election. And if Trump wins back the White House, and right now it looks like he's going to win back the White House, he can order the Justice Department to just drop all the federal charges. The majority opinion was from Chief Justice John Roberts. He writes, a former president is entitled to, quote, absolute immunity from criminal prosecution for actions within his constitutional authority. Roberts went on to say that Trump's attempts to get Mike Pence not to certify the election, they, quote unquote, involve official conduct. My head is spinning from that. I can't wait to find out more about how that could possibly make sense. But
all that's happened, the best is yet to come.
The dissenting opinion came from Justice Sonia Sotomayor, who says, let the president violate the law, let him exploit the trappings of his office for personal gain, let him use his official power for evil ends. That is the majority's message today. She even adds, the president is now a king above the law with fear for our democracy. I disagree. That is a powerful dissenting opinion and a lot more, I would argue, polemic than I'm used to hearing from the court, certainly from Sonia Sotomayor. Elie Mystal, who is a brilliant legal mind, a wonderful author, and someone who has a very rich and nuanced understanding, not just of the law, but of the Supreme Court itself. How big is this decision?
It's terrible. It's the worst. It's worse even than I anticipated. And I anticipated that Trump would win. I anticipated it would actually sound like you made it sound in your opening, that Trump is immune from some things, perhaps not others. Perhaps the lower court has to think again about what. No. This was worse than even what you said. You quoted the key line. Trump has absolute immunity from prosecution for criminal acts that he takes while under his constitutional authority. Now, to put that in context, you have to put that in legal context. Many of your viewers are going to be familiar with the idea of qualified immunity, right? That the police officers have, like any government official has. They have a qualified immunity for acts that they take while in their official capacities. But now let's distinguish qualified immunity like the cops have and the absolute immunity that the Supreme Court just gave to Donald Trump and every future president going forward. Right there in the words, the difference between qualified and absolute is pretty stark, right? With qualified immunity, even though you may be immune for some of your, for some of the things you do while on the job, you are not absolutely immune. That means that you can bring evidence against a person to say, like, oh, they usually have immunity, but they shouldn't in this case. With presidents, with Donald Trump, you can't do it. He is absolutely immune now, forever and ever and ever.
What's the logic behind that?
Evidence that you are allowed to bring against the president. Moreover, in qualified immunity, we're talking about qualified immunity from civil crimes. You don't have qualified immunity for criminal qualified immunity for civil issues. You don't have qualified immunity from criminal acts, right? So Derek Chauvin could say very well, oh, murdering black people is part of my job, but you don't have qualified immunity for crimes if you're a cop. But you do if you're president. So even if you can prove that the president committed a crime, that president now has absolute immunity from being prosecuted for that crime, as long as he says, oh, that was part of my official responsibilities. So it is a sweeping decision, the likes of which we have not only never seen in this country, the likes of which you don't see in republics, right? You don't see in democracies. You don't have a democracy or a republic if there is one what Augustus Caesar was called first citizen, right? And that's what the Supreme Court has made presidents now first citizens that are different than the rest of us, citizens that are not subject to the ruler of law or the penalty of law, because they are above the law, because they are absolutely immune as long as they say they were doing the job of the president.
What's the best defense of Chief Roberts? What's the best defense of this argument?
The best defense of the argument, well, I guess you go two ways. One, presidents already act like they have absolute immunity, so now we're just formalizing it, right? The reality is we have not prosecuted presidents in the past when they have arguably committed crimes. We didn't prosecute Bush or Cheney after the Iraq War. We didn't even prosecute Nixon. We perhaps could have prosecuted Nixon. He was gonna get prosecuted. He got pardoned, so we never even had to test it with Nixon. And you can go back through the history. No president has ever been prosecuted for a crime after they've left office. So the best argument is that the Supreme Court was merely formalizing a tradition that we have in this country of letting our presidents off the hook. Now, I think that is a poor argument, because I would argue that no president has ever tried to overthrow the government, but you ask for their best reasoning. The other kind of version of their reasoning is to argue that there is some scope of unofficial acts, right? Some acts that a president takes when they're not acting in their official capacity that could still be charged with a crime. Arguably, I don't, and this comes to my mind.
Just for example, so Donald Trump were a serial killer on weekends. He just goes back to Florida, goes back to Mar-a-Lago, and just starts hacking people up. That he could still be prosecuted for that. But if he were to commit an indisputable war crime, if he were to say, I am going to commit a war crime as a matter for the purpose of enhancing national security, even if we all agreed that it were a crime, that he violated the rule of law, etc., because it was an official act, there's nothing we can do about it. Is that the distinction? Just to be clear,
that is the distinction according to Roberts. This is still in the making the best argument for Roberts case. Right. Yes, the distinction is the president could order a war crime that cannot be prosecuted, but if the president went home and just hacked and slashed some people on the side for funsies, that would be an unofficial act. The problem with that reading, even from Roberts, is that he doesn't tell us how to figure out if a president's acts are official or unofficial. He gives almost no guidance about how to figure out whether or not an act is official or unofficial. And incredibly, he also changes the standard of evidence that can be brought against the president, right? So if I wanted to prove, for instance, that hacking people on the slide was not an official act, I might want to show statements statements a future homicidal president has made in further, hey, Billy, I'm going to hack some people. But according to Roberts, statements that the president makes to their advisors cannot be used to implicate them in unofficial acts. Statements that the president makes in public cannot be used to implicate them in unofficial acts, because talking to advisors and talking to the public are both official acts. So you can't use even that evidence to try to establish whether or not a president was killing people on the side for fun or killing people on the side because he's president and was trying to save national security, by killing the hobo under the underpass, right? Like that's the argument here. So functional. Yeah. So while Roberts theoretically allows there to be a distinction between official and unofficial, functionally, he gives us no way to figure out what unofficial might even look like.
Wow, this is quite scary. The only other question I have for this, and I'm really asking to understand it fully, there are things that no president can do, or that no one can, like treason, for example, right? How do we even? It seems as if now there's no mechanism, if I'm understanding you right, to even unpack that. I mean, for example, if a president were to say, any geriatric president who doesn't know where he or she is at the moment, and they decided that instead of letting the country know that, they would just let the chief of staff run the country for a year or two, behind the scenes. That would be illegal. It's like really like a coup.
Well, who says that's illegal now? Not that might have been illegal yesterday, but that's not illegal today.
That's an official act.
That's not illegal anymore, dude. I mean, it's just not. You said treason. Like, treason seems like so obvious. Here's how treason now looks under Roberts' new statute, right? Let's say I'm president and I want to do some treason, right? So I want to go, hey yo, South Africa, yo, I got these nukes. You want to know the nuclear secret, right?
The nukes on the low, yeah.
Right. And then they say, oh, it's treason. You're trading state secrets. So it's like, no, I'm negotiating. What? I'm negotiating with an ally. It's a part of my official job as president to negotiate foreign treaties. I'm trying to get a negotiation. Yeah, some words were said, some secrets were shared, but I'm the president and I get to negotiate. And again, that can't be prosecuted. I could still be impeached. And I do think it's important to kind of understand that this doesn't affect the impeachment power directly. So Congress can still impeach a sitting president for high crimes, even though a sitting president can no longer be prosecuted for high crimes. A president could still be impeached for high crimes. Okay. But the thing about the impeachment clause is that it does nothing to stop a president who's already left office, right? So if you get into office, you can go on a 4 to 8 year crime spree, stealing as much money as you can stuff in your pockets, calling it official embezzlement as opposed to private embezzlement. And if Congress doesn't impeach you and you make it through your 8 years, you can take all that money and go to Bali and nobody can ever do anything to you.
Well, shit, you don't have to go to Bali.
Because you are exactly. You don't have to be on the land.
It doesn't matter. You can't prosecute you.
You are forever immune from prosecution. So, I mean, look, you talked about Sotomayor's dissent. She straight up says this is the power we've given to kings. Justice Ketanji Brown Jackson also wrote a dissent where she kind of really directly outlined how this was a king-like power and called into question how you could possibly think that as an originalist, the founding fathers who were escaping a king could have possibly wanted to erect a presidency that had king-like powers. So all of that was said in the dissents. All of that was said by the liberal. This is not me making it up, is what I'm trying to say. The liberals on the court were like, this is the power we give to kings. Republicans don't care. They want Trump to have this power.
So that's the thing that just to move it forward really quickly, like Ketanji Brown Jackson's dissent is actually quite important here, and that point you raise is a critical one. That is to say, conservatives are skeptical of too much government power. I thought even the argument last week, around government regulation, you could at least make the case that they're trying to shrink the government, that they don't want all these federal bureaus. They don't even want the EPA to make determinations about, to adjudicate competing claims about what's clean air or whatever the thing might be, right? I can at least see that with the ideological through line, even if I disagree with it. But this seems to be granting to the government and to a single person the very power, as you and Ketanji Brown Jackson pointed out, that we kind of fled England for, or they fled England for. We ain't flee nowhere. So yeah, we had a different course. But I guess what I'm saying is, are the judges on the Supreme Court actually just being activist judges in the interest of a particular president, or is this just an ideological contradiction that all of us have? To put it simply, why are they doing this?
It's not a contradiction. The through line, the connective tissue between their ruling in Chevron and their ruling today is that who ultimately gets to decide in all of these cases now? Them. The Supreme Court. It is the Supreme Court, not the government agencies, that now get to decide which environmental regulations are good and which are faulty, which financial regulations are allowed and which are not. And it's the Supreme Court in their sole arbitrative function that get to decide which acts are official and which acts are unofficial. They can pick, again, as I said, the key to them not giving us an answer, not giving us a way to figure out for ourselves what an official act is versus an unofficial act means that only they get to tell us, which means only they get to know what an official or unofficial act is, which means only they get to prescribe the actions of a president. And that's what they want. So when Trump orders a coup against the government, that's an official act. But if Biden ordered SEAL Team 6 to drop in on Mar-a-Lago and have a destruction con party, that might not be an official act, and only the Supreme Court gets to decide. So the connective tissue is their own power. They don't give a damn about the government having too much power. They want all the power for themselves. And that is what they've done over the course of this week, not just in these two cases, but if you look at all of their cases coming here at the end of June, all of their like end of term cases, every single one of them puts more power in their hands, people who nobody voted for. And that's the why. That's the, to the extent that you're looking, Mark, for that, you know, what's the real story here? That's the real why.
So what's the redress here before we go? What can be done to fix this?
You got to expand the Supreme Court. Because the Supreme Court has decided that they're the only ones allowed to have power, the only way you stop them is if you put additional judges on the Supreme Court who either don't want to have that power and will give it back, or will use that power in ways that you like. You know, you can pick which. I happen to be on the they should give the power back side, but if you also could make an argument that, like, actually we just need to put liberal judges on there so they can just take the power and do the right things with the power. Like, if the Supreme Court is going to be the only institution that is allowed to hold real power in this country, then it is political malpractice for the Democrats to allow 6 conservative justices to run the Supreme Court for the next 20 or 30 years. That can't be allowed. So the only solution, and I mean the only solution, is to elect Democrats who don't want to do court packing, make them do court packing, make them get rid of the filibuster in order to do court packing, which they also don't want to do, then make them appoint judges to the Supreme Court that are going to be willing to give the power back, which is another thing that's difficult to get through.
Is that not a scary and maybe even slippery slope? I mean, so you pack the court, or you try to pack the court, and then Trump comes back around, or the new Trump in 4 or 8 years comes around, and now it's not 6-3, it's 8-3.
Yeah, it doesn't matter. See, that's the thing. We are already, it's like if you are underwater, right? And somebody's like, I'm going to pour some water on your head. Why the hell you care? How is that any worse? Like, we already have a permanent conservative majority on the Supreme Court for the rest of my life and yours. If Trump comes in and packs the court, and the difference between 6-3 and 10-6, the difference between 6-3 and 16-3 doesn't matter. They're already winning, right? If Democrats pack the court, at least you have an opportunity to redress some of these issues, give some of the power back, restore some voting rights, and force Republicans to repack the court on top of your court packing, having to actually win free and fair elections that are maybe ungerrymandered this time, right? So, like, there's nothing more that, put it like this, Mark, and I'm sure you've thumbed through the 900-page Project 2025, right? The conservative fascist plan to take over the government. You know what's not in Project 2025? Any section on the Supreme Court. Why? You think they forgot? You think they didn't know what this? No, they already have the Supreme Court.
Right.
Right? They already won the Supreme Court. They don't have to waste any of their 900 pages talking about how they're going to take it over, because they've already taken it over. So if you want to stop them, the first thing you have to do is take the court away from them. And one way to do that is with court packing.